Please join me as we welcome the newest member of the INCOMPAS team, Lindsay Stern. She is an attorney and policy advisor, and she works on a myriad of issues. Today, Lindsay will be introducing a very timely and important topic concerning Section 230 of the Telecommunications Act of 1996. Lindsay's presentation will focus on the Ntia petition that is pending at the FCC. Following Lindsay, there will be a session moderated by Gigi Song, the Distinguished Fellow at Georgetown Law Institute for Technology, Law, and Policy. She's also a Benton Senior Fellow and Public Advocate. She will lead a panel of experts who will discuss what's at stake and why it matters regarding Section 230. Two great panels, very important subject, very talented panel. So I look forward to these discussions. And as we and all of our member companies work with the FCC and members of Congress on this critical issue to the internet economy. So thank you to Lindsay and to Gigi.
Today, I'd like to give you all an update on Section 230. The title of this panel is Section 230, what it means and where we are at the FCC. And that is what I'll try to get across today. What exactly is Section 230? Why is this issue currently at the FCC? And what is INCOMPAS's position? I'll begin with a quick background on Section 230, an overview of NTIA's petition for rulemaking at the FCC, how the regulatory process works at the FCC, and INCOMPAS's opposing position on the NTIA petition. First, let me start with some background on Section 230. Section 230 of the Communications Decency Act was passed by Congress as part of the Telecommunications Act of 1996. And I'll simply refer to it as Section 230. For those of you who want to look up the text of the law, it can be found at 47 U.S. Code Section 230. Section 230 protects websites, online platforms, social media, as well as ISPs from lawsuits if their users post something illegal, although there are some exceptions. To be more specific, most of the attention on Section 230 is on subsection C, which is the protection for Good Samaritan blocking and screening of offensive materials. In other words, Section 230C is the part of 230 that provides the legal immunity regarding the third-party speech of users. Section 230 has recently received a lot of attention, especially on the Hill, at the FCC, and even at the White House. Then Representatives Ron Wyden, a Democrat from Oregon, and Representative Chris Cox, a Republican from California, drafted Section 230 so that websites could moderate content posted on their sites without worrying about legal liability. They believed that the internet as a form of media was inherently different than other forms of traditional media, such as broadcasting or newspapers, which have extensive control and oversight of the publications, and that is one outlet expressing itself to its mass audience. But the internet flips this idea, as now millions of users can express themselves online using one or more websites and/or social media outlets. Section 230 was passed to address a judicial precedent that would have held websites and online platforms liable for third-party content. Congress was concerned that such a result would significantly limit the development of the internet and online services. Congress also wanted to incent online providers to take down inappropriate and illegal content so that the internet would be more family-friendly. Section 230 more recently has come under scrutiny due to specific content moderation decisions. Some people want online companies to remove more content or act faster to remove content that they consider harmful. Some believe the legal protections that Section 230 provides to websites are too broad and do not incent online platforms to remove harmful content. Others have accused online platforms of removing political content that they disagree with, harming individuals from expressing their views online. Most recently, the Trump administration filed a petition for rulemaking with the FCC, asking it to implement rules that would limit the use of Section 230. But before we get to that part of the discussion, I first would like to provide you with a further understanding of how Section 230 functions to promote online content, diverse offerings, and free expression. To get deeper into the law, Section 230C is broken down into two sections that provide legal protections to websites and online services. In fact, Professor Jeff Kosif wrote an entire book on Section 230 entitled The 26 Words That Created the Internet, which is a reference to Section 230C1, which states the following, quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider," end quote. There is a statutory definition of interactive computer service, but essentially in plain English, this section says that websites and other online services will not be treated as the publisher or speaker of third-party content on their websites. This is significant for online services because there can be legal liability for speakers and publishers, such as defamation. And this section says that these companies will not be liable for third-party content. The actual speaker or publisher can still be liable, but that liability does not then translate to the online service. For example, if I write a defamatory comment on my Facebook page, I can be sued, but Facebook cannot. Now moving to Section 230C2, which addresses civil liability for content moderation. Section 230C2 states, "No provider or user of an interactive computer service shall be held liable for A, any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. Or B, any action taken to enable or make available to information content providers or others the technical means to restrict access to material described above." In other words, C2 provides legal protection to a website or online service that decides to moderate content under a good faith assessment that they find the material objectionable. That way, for example, if Facebook does decide to take down the picture I posted that was inappropriate, let's say it included a level of violence that Facebook doesn't permit, I cannot sue Facebook for taking it down. It's important to recognize that there are exceptions to Section 230. In Section 230E, Congress laid out the effects of other laws on Section 230 and when the protective immunity does not apply. Section 230 does not protect a service from criminal laws, intellectual property laws, state laws that are consistent with the statute, communication privacy laws, and sex trafficking laws. For example, if an online video distributor posts a copyrighted movie without permission, then Section 230 does not provide legal liability protection for that. Section 230 has incented online providers to moderate content and take down what's harmful, and it has allowed the development of new services that provide individuals opportunities to share online. As a result, we now have websites and services devoting to helping consumers find the best products and services, from individual online reviews and websites devoted to individuals creating and posting their own content, whether it's blogs, videos, or their favorite cat pictures. So why does Section 230 matter? INCOMPAS and its members believe in the importance of online competition, innovation, and investment. In the US, we currently have a diverse internet ecosystem that allows companies to compete based on the content that they offer. Because Section 230 provides some legal immunity to online platforms, websites, and other providers of third-party content posted online, we have seen a diverse array of content and services online, and the offering of new competitive services that are competing against one another and traditional content providers. This has led to better services for consumers across every economic sector, as well as more informed consumers who often rely on the third-party content that Section 230 protects, such as posting and reading online reviews. On May 28th, President Trump signed an executive order entitled Preventing Online Censorship. Out of the various things the executive order did, the most relevant to us is that it ordered NTIA, or the National Telecommunications and Information Administration, to file a petition for rulemaking within 60 days with the FCC, requesting that the Commission clarify provisions of Section 230. And on day 60, which was July 27th, we saw just that. NTIA filed a petition for rulemaking requesting that the FCC promulgate rules related to Section 230's use that would be enforced by the FCC. Specifically, NTIA requests that the Commission propose rules that would limit the ability of online services to use Section 230 as a liability shield. I'd like to give a brief overview of the regulatory process at the FCC in this proceeding. Pursuant to the FCC rules, the FCC issued a public notice and seeks public comment on petitions for rulemaking. In this proceeding, NTIA filed its petition on July 27th, and on August 3rd, the FCC issued a public notice to allow those in the public to file comments opposing or supporting the petition. The FCC gave the public 30 days until September 2nd to file comments and 15 additional days for reply comments. INCOMPAS filed comments opposing NTIA's petition. INCOMPAS opposed NTIA's petition for three main reasons. First, the regulation of online content would harm online competition, innovation, investment, and free expression. Section 230's purpose was to enable online platforms to develop and allow for free expression and to create a safe internet ecosystem rather than be stifled by significant liability risks. Section 230 enables the competitive free market to determine how online services are developed and consumed, including by providing the opportunity for various services to flourish based on consumer choice. As mentioned, the US has a rich, diverse internet ecosystem that allows companies and individuals to offer content based on their own customers' desires and needs. Section 230 has also provided the opportunity to engage and have third parties submit their own content and have their voices heard via liability protection. With the protections of Section 230, an online provider can offer content that their consumers want to see and remove content that their consumers do not want to see, such as videos that are violent or explicit. Free speech also means the freedom for private companies to develop what content they want to carry. NTIA's petition would micromanage the way online platforms operate and invite the FCC and trial lawyers to second-guess every decision regarding content moderation. We warn that if the FCC moves forward with NTIA's petition and limits the protections that have led to the proliferation of online content and competition, it would be much harder for companies, especially new entrants and small companies, to meet the requirements of the proposed regulations, as well as the development of new competitive online services. While the president may have signed the executive order in response to the actions of a particular well-known technology company, and even calls out online platforms like Twitter, Facebook, and YouTube, that does not mean this proceeding will only affect established service providers. Rather, granting NTIA's petition will be felt far beyond these platforms, and arguably even more by smaller and emerging online companies. If the FCC adopts regulations, it would be much harder for new entrants to meet the regulatory requirements, which could harm investment and the availability of new online services. Startups and smaller businesses that fear endless lawsuits and financial liability for the content on their website may decide to no longer compete or even enter the market. Second, NTIA's petition asks the FCC to legislate on Section 230, but legislating is clearly the job of Congress, not the Commission. NTIA's petition asks the FCC to go far beyond its traditional rulemaking role. Rather than asking the Commission to implement a statute by promulgating rules, NTIA is requesting that the Commission provide new interpretations of a statute and is essentially asking the FCC for new legislation rather than its traditional role of creating rules to implement the statute. The changes this administration seeks for Section 230 should be up to Congress, not the FCC. And this administration should work with Congress in figuring out how, if at all, to modify Section 230. While Congress and the administration should carefully consider the potential impact of such changes on online content, competition, and free expression, there is currently a lot of attention on Section 230 in Congress, and we have seen various congressional hearings and proposed bills. In fact, Congress is currently considering modifications to Section 230, and that is the appropriate forum for the administration's focus, not the FCC. In addition, NTIA is asking the FCC to intervene where the statute already has been interpreted by the courts. Yet Congress's expectation was that the courts would interpret the statute. And as a result, the courts have a tremendous amount of experience and precedent doing so, and companies have relied on those interpretations. Third, the FCC should deny NTIA's petition because the Commission has a tradition of not regulating online content. When this Commission repealed the net neutrality rules, it issued the Restoring Internet Freedom Order, where it decided on light touch regulation of Internet information services, including broadband internet access services, or BIAS. It would be illogical and quite odd for this FCC to now grant NTIA's petition and regulate online content and services of all types, but not to regulate BIAS services that are used to deliver those services. An FCC that stood by its decision not to regulate BIAS, but the information that flows over BIAS, would be the equivalent of not regulating telephone service, but regulating what users can talk about when they make phone calls. In fact, the Restoring Internet Freedom Order extensively cites Section 230 as to why the Commission should not regulate Internet information services and BIAS services. In the Restoring Internet Freedom Order, the FCC relied on Section 230 to show the importance of the free market and as evidence for the need and authority to prevent government regulation. Overall, INCOMPAS believes that this administration is demanding that the FCC regulate online content, even though it is contrary to the First Amendment, Congress's intent, and the FCC's own precedent. We have urged the FCC to deny NTIA's petition and have warned of its potential to harm online competition, innovation, and investment, and that this is a legislative issue that should be left for Congress. So that is all I have for you today. I'm so glad you tuned in to watch this video. I hope you learned something today, and feel free to contact me if you have any questions or comments. Thank you. Before we go to the next panel, here's an entertaining video that was made by Extra Credits to further walk you through the background of this serious topic.
You may have recently heard proposals by U.S. politicians calling for reform on something called Section 230 of the Communications Decency Act. In case you didn't know, Section 230 is commonly referred to as the 26 words that created the internet. So what does it mean when President Trump signed an executive order in May calling for Section 230 platform immunity to be clarified? And how might these reforms affect the games industry? To once again help us jump through this legal jargon jungle, we've called on our lawyer friends Joe, Rebecca, Andrew, and Aaron at Fenwick & West. And if you've seen some of their other episodes, you already know that standard verbal fine print applies. These are just their opinions presented in animated video essay form, not legal advice, and you should always consult a real-life lawyer if you need help. We've put links to their bios in the description, along with some other useful articles for further reading on this topic. But okay, way back in ye olden times of 1996, only 26% of Congress members even had an email address, much less surfed the net. While some politicians were proposing regulating the internet like TV and radio, Senator Ron Wyden and Congressman Chris Cox recognized that the internet was special. Unlike TV, internet users could publish their own content and interact in real time. Wyden and Cox were worried that government regulations would unleash a swarm of government censors that would harm the baby internet and ruin what made it special. So they drafted an amendment, which would eventually become the Communications Decency Act as we know it today. CDA 230 has two major parts, 230C1 and C2. C1 provides that, with some important exceptions, providers such as YouTube, Gmail, online video games, and even your ISP, and users, like you and your friends, generally can't be held liable for what other people publish online. This means that if someone posts something defamatory or inappropriate on Twitter, Twitter won't be held responsible. But it also means that if you retweet it, you won't be held responsible either. So you can kind of think of this C1 as a shield. Incoming lawsuit deflected. The other section, C2, provides that so long as a platform acts in good faith, they may, but don't have to, remove content that they find objectionable. And you can kind of think of C2 as a ban hammer. Platforms can wax slime with C2 safely, knowing that the posters can't sue them for censorship. Now, Section 230's shield isn't all powerful. For example, it doesn't provide immunity for platforms whose users violate intellectual property law, such as copyright. More recently, Congress amended Section 230 to make platforms responsible if they facilitate prostitution or sex trafficking. Though whether or not those laws were executed well is its own can of worms we won't get into here. Additionally, one court ruled that when a platform actively induces its users to post illegal content, it also loses its CDA shield. And lastly, the CDA doesn't apply when a platform speaks for itself, editing users' content to fit the platform's viewpoint. So now that you're familiar with the basic outlines of Section 230, you might be asking, why all the recent attacks? Well, wouldn't you know it, both liberals and conservatives have something to dislike about Section 230. Some liberal commentators think that the big platforms have become complacent with their C1 shield immunity and have allowed hate speech, harassment, stalking, lies, and other horrible things to run rampant. Checking my Twitter feed here, yep, that seems anecdotally correct. Gugh. On the other side, some conservative politicians, including President Trump, claim that big online companies are using their C2 ban hammers in bad faith to selectively censor their views. Though granted, the data doesn't really bear out on that, but these days, when has that ever stopped anyone? So Trump signed an executive order in May of 2020 that directs both the Federal Trade Commission and the Federal Communications Commission to get involved in combating online censorship. Meanwhile, tons of legislative proposals are floating around to fix 230, ranging from giving attorney generals the power to pierce Section 230's shield immunity, to creating new government commissions to craft mandatory internet best practices, to taking the shield away entirely unless a platform proves to the US government that its ban hammer is politically neutral. Lots of hard air quotes in this episode for obvious reasons. The problem is that many of these proposals engage in the same kind of large-scale, content-based speech policing that Wyden and Cox were worried about way back in the 90s. Oh, and having the government sanction what is politically neutral? Can't imagine how that would ever go wrong. But let's bring this back to games. As you may know, the games industry has been grappling for a long time with toxicity, as anyone with a passing familiarity with Gamergate can tell you. But all of the proposals that we've seen so far would severely hurt the games industry. A weakened 230 shield could chill game speech by making companies nervous about getting sued for something a player posts, and in response, could lead to them disabling comments, chats, and even customizable outfits and usernames. Less talk, less liability, right? Heck, game companies might even decide to reduce all interaction to canned chat. Well played, I guess? On the flip side, game companies rely on their Section 230 ban hammer to act against their most toxic players without fear of a lawsuit. And whether or not specific companies are currently using it effectively enough, without this strong ban hammer, the worst trolls would go unvanquished and further ruin everyone else's time with the game. Not to mention this could be particularly devastating for smaller developers, where a few bad actors can have a massive impact. A small bit of good news is that all of these proposals are still new. They'll need to go through both houses of Congress to become laws, which will take time, and is unlikely with the current garbage fire of, most everything. And if any pass, they will almost certainly be challenged as unconstitutional. Now, as for Trump's executive order, it's important to remember that the president does not enact, or even write, laws. An executive command might feel scary, but it has no real effect on game companies right now. Nevertheless, pay attention. Even Democratic nominee Joe Biden has gone on record saying he wants to revoke Section 230, albeit to fight misinformation, so this isn't a debate that's going to disappear anytime soon. Section 230 is central for game developers, both large and small, for building the online community they want for their players and for protecting their game's unique qualities from those that might ruin the experience. Each community is different, and each has its own rules, and that's okay. That's not a bug of the internet, it's a feature. And if you are a developer, remember that for now anyway, you have the CDA shield and ban hammer in your armory. So please, use them responsibly. See you next week, everyone. Legendary patron roll call. Ahmed Ziad Turk, Alicia Bramble, Casey Mustia, Dominic Valenciana, Gunnar Clovis, Kyle Murgatroyd, and O'Reels1. Thank you so much.